Good morning. It is the appointed time and we have a quorum. I call to order the meeting of the Bills Committee on BHU Bill. I have forgotten which meeting this is. This is the fifth meeting. All 15 members are all present sharp at 8:30. Item 1, meeting with the administration. All the government officials are here. We are familiar with them. I will not introduce them one by one. Let's continue with the clause-by-clause scrutiny. On the last occasion, we were at clause 15. Today, we will start from clause 16. Please refer to page C3472 of the bill. We are at Part 4, Division 1. Mr. Chan, please. Thank you, Chairman. This is Part 4. Basic housing units recognition of subdivided units. There are altogether 5 divisions, 12 clauses, 16 to 27. The purpose is to provide for the legal framework of the BHU recognition system. And also, they supplement the operational details. Division 1, recognition of SDU as basic housing units for permitting letting. Clause 16, Secretary may recognize subdivided units as basic housing units. It sets out that the recognition period validity is 5 years and can be renewed for another 60 months. Clause 16, Ms. Doreen Kong, as usual, 4 minutes, questions and answers included. Very briefly, Chairman, 16, subsection 3. The English text may renew or further renew. Why is further renewal need to be mentioned if only one renewal is allowed? Ms. Wong, good morning, Chairman and members. Simply put, there can be more than one renewal. Now, the first application is for recognition. It comes with a 5-year validity period. After that, the operator can apply for a renewal of the recognition. When the second 5-year period has ended, that is after 10 years' time, if the operator wants to continue operating the BHU, they can apply for another renewal. So there can be unlimited renewal if the requirements are met. Yes. Any more questions about Clause 16? If not, Clause 17. Thank you. Division 2, application for BHU recognition. Clause 17, it sets out the procedure for applying for recognition. As mentioned in the last meeting, the system is the same as applying for grace period. The landlord or an authorized person has to make the application. Concerning the fees, when scrutinizing Schedule 2, for the first 3 years, there is an early bird waiver of fee. I will not repeat what that's about. And besides the application, a report compiled by a professional must be attached to certify that the SDU meets the minimum standards of living conditions and that all the liability arising from statutory order, notice, or direction has been discharged. Now, the report must include the on-site inspection and preparation and the on-site inspection of the principal flags conducted by the professional. Mr. Tony Jie. One point of clarification. It mentioned on-site inspection conducted by the professional. The inspection may not be conducted by the specified professional themselves. They may engage other personnel to conduct the inspection. So is that allowed? So some may say that the landlord himself can be the one conducting the inspection. Mr. Tony Jie, thank you for your question. The on-site inspection should be conducted by the specified professional to compile the audit report. The responsibility is on the professional themselves. So they are the ones to decide who should conduct the inspection, because the professionals themselves have to take responsibility for the audit reports compiled. So whether it is the landlord or the professionals hired by the specified professionals, whichever it is, the specified professional has to take responsibility of the contents of the report. So it's up to them to decide. There is a requirement here for the specified professional to certify that his or her opinion, it is in his or her opinion that the flat meets the standard. So they are well aware of their responsibilities. They have to stand by their opinions. So they can't shift the blame that the inspection is conducted by someone else and they take no responsibility of the report. So they have to take responsibility. Mr. Lam Chun Sing. Thank you, Chairman. I'm also concerned with the question raised by Mr. Tony Jie. An on-site inspection that is conducted or arranged by the specified professional. So if the professional arranged for someone else to conduct the inspection for them, then is it the case that anyone at all can conduct the inspection? Or is there a requirement that the person conducting the inspection must have certain qualification in relation to the profession, for example, an electrician or a plumber who is qualified to inspect the fittings of the house? So should these be at least technical personnel, if not professionals? Now, even so, the main responsibility holder should be the specified professionals. But what about the technical personnel assigned to inspect the house? Will they have to take responsibility legally as well? Ms. Wong, our position is the responsibility is with the specified professional. We will provide for some flexibility here. They are in charge of compiling the report. Having read the inspection report compiled by the technical personnel, if the specified professional is confident to sign off the audit report, then we respect that decision. Now, for a report compiled by a non-professional, if there are doubts, the specified professional can conduct the inspection again by someone else or themselves. So at this moment, regardless of who is assigned to inspect the house, the responsibility is with the specified professional whose name is on the audit report. So they must be 100% sure that the audit report is proper. Ms. Doreen Kong. Subsection 1(4) or 1(c), any liability must have been discharged. Now, so for building orders, the liability cannot be discharged shortly. So if I show the payment slip to the owner's corporation, can I assume that my liability has been discharged? Subsection 2, the on-site inspection conducted or arranged by the professional of the principal flagged. Now, can I confirm this with the Permanent Secretary? Concerning the inspection of the principal flagged outside of the principal flagged, is the inspection only in relation to the 5 safety requirements? Ms. Wong, concerning discharge of liability, it refers to statutory orders and notices. Concerning discharge of the liability, the relevant departments would issue a notice notifying the liability holders that the liability has been discharged. So only then will we consider the liability discharged. Second question, on-site inspection by the specified professionals. The inspection should be conducted on the principal flagged concerning whether the minimum standards of living conditions have been met. So the main purpose of the inspection is to see whether the minimum standards of living conditions have been met, whether it is the principal flags and the other SDUs. Mr. Vincent Zhang, my question is about the prescribed fee. Now, in my I'm involved in helping residents in old buildings. Now, under the Operation Building Bright, there's a range for maintenance fees for various items. Now, sometimes the technicians would invite you to conduct other minor repairing works on top of the other necessary works. So can we offer more guidelines to minority tenants or landlords so that they understand how much the fees should be for compilation of the report? Concerning the fees for engaging a professional to compile the audit report, we have been communicating with the professional bodies, but it varies case by case. For straightforward cases, it usually just involves several $1,000s. But if the case requires multiple visits and more complicated items, then the fees would be higher. In the future, we will launch a website for basic housing units. We will liaise with the professional bodies to offer some reference prices for landlords' benefit. We understand that landlords would like to know the ballpark figure for engaging a professional. Now, for renovation of old building, the URA would offer a lot of guidelines and directions to landlords to help them avoid pitfall like price rigging. So I hope there will be more guidelines and instructions. Dr. Wendy Hong, 2 points of clarification. If an SDU has met all the requirements, but there are some liabilities outstanding, does it mean that it cannot be recognized? And about the fees for applying for recognition, under the early bird discount, who will be the one receiving the payment, the professional or the government? Under the early bird discount, will the government be subsidizing the fees for engaging the professional? On your first question, if there are outstanding liabilities, I mean liabilities arising from orders issued by the buildings departments and the fire services departments. Anyway, they are all specified in the legislation. If orders have been issued to the flagged, then in recognizing the SDU, we have to confirm that all the orders have been complied with. So it's not just any legal liability. It's the specified orders in relation to building and fire safety. For those orders, unless the liabilities have been discharged, we cannot recognize the fact. Now, recognition fee is the administrative fee charged by the government. That is, upon submission of the application for recognition of BHU, our colleagues have to do paperwork and conduct site inspection. So we are recovering that fee, $3,000 on a cost recovery basis. But as mentioned, we have an early bird discount. For those who have registered early, you can have the $3,000 waived for the first year. Concerning the fee charged by specified professional to compile the audit report, we respect the market's decision. But as mentioned by Mr. Vincent Zhang, landlords need some reference prices from the professional bodies. So we have been discussing with the professional bodies to understand various fees charged by professionals for various cases, so the government will not interfere with the price decision. Does it mean that to apply for recognition there are several fees? First, the administration fees. Second, fees charged by the professionals. And three, cost of alteration works. Correct. Mr. Kenneth Leung, I would like to follow up on the early bird discount. In particular, the recognition fee of $3,000 charged by the government. As the Permanent Secretary has said, that is the administrative fee charged by the government is different from the audit report fee. I think that's quite confusing. Anyone outside of this Bills Committee would have thought that the early bird discount and the $3,000 waiver means that you don't have to pay a dime to compile the audit report. So maybe we have to be more sensitive about the name of the discount. Ms. Wong? Understood. After the passage of the bill, we will launch a publicity campaign so that the stakeholders understand that besides the $3,000 application fee, other costs are involved in engaging a specified professional to compile the report and also the alteration works. Any more questions about Clause 17? Dr. Starry Lee. Chairman, prescribed fee and specified professional certification. Now I can foresee that there will be a lot of SDUs requiring certification. According to my own experience in building maintenance, in a short span of 3 years, there will be a lot of minor works being conducted. So I hope that the administration can help compare the prices here. Now I think we all have experience during the Operation Building Bright. There were some professionals who quoted a low initial price but then charged a much higher fee. That caused lots of grievances among the landlords. So I hope there would be a mechanism as a safeguard. I think the threshold is quite high. You are asking pre-existing SDUs to be modified to meet your requirements. A lot of work is involved. I think you are underestimating the complexity of this issue.
Ms. Wong, point noted. I thank Ms. Lee for her question. Indeed, we have not underestimated the difficulties. Among the 110,000 SDUs, 70,000 of them will be able to fulfill our minimum requirements by some simple modifications. For instance, by placing a fire extinguisher. For the remaining 30%, that is about 30 to 40,000 SDUs. They are not able to meet our minimum IFA requirement of 8 square meters. For those cases, the alteration required is a bit more, and we have about 8,000 specified professionals qualified in the market. We have 48 months, that is 12 months of a registration period and 36 months of grace period. That would be sufficient for the 30 to 40,000 SDUs to be modified. We believe that the market will be able to digest the demand. Having said so, we heard members' view, and then in our dedicated website, we will have information, and we have a phone number for our office. And if the industry has inquiries about the minimum standards, we will have someone to answer the inquiries. We understand that a few professional bodies are liaising very closely with us. They are considering whether they can provide advisory or consultation services. In the coming few months, I will work out the arrangements with them. Thank you. Just a very simple point. Thank you for your sharing. I believe you have assessed the situation, but according to my experience, the period given in orders by the BA are longer than 3 years, and I can only say that the price differentials and various problems are numerous. I hope you can really seriously consider this matter. I'm quite worried that 3 years is not really that long for a repair and maintenance order. Usually it can be 5 years and still the issues are not settled. It's much better since the URA started to help, but then as we all know, this is a long-standing problem. Thank you. If there are no further questions, we move on to Clause 18. Thank you. Clause 18, determining applications. This is about the Secretary may take into consideration matters in determining application, such as document information required, and also the finding of any inspection carried out within the unit and any code of practice. And the Secretary may also refuse an application under the following situations. First, if the application doesn't comply with the requirements to produce a document, or refusal to carry out on-site inspection, or statutory orders that have not yet been discharged. And if the Secretary is satisfied that any document information provided is false or misleading, or if the SDU does not meet the minimum standards of living conditions, or if there is an imminent danger or risk to life or property in the subdivided unit, its principal flat, or the common parts of its principal building. And to cater for unforeseen circumstances, we have also got a catch-all phrase to allow the Secretary to refuse an application for any other reason, and that could include the flat or the unit being used for illegal purposes. Mr. Andrew Lam. Thank you, Chairman. Any other reason? In many licensing regimes, if there is illness incorporation, then the DMC will be taken into account. And in cases where no OC is present, then the views of neighbors can also be taken into account. So for any other reason, does that include views of the local community as well as conditions in the DMC? For instance, if the Secretary has received views from the OC, Owners Incorporation, or views from the local community, will that be taken into account or not? Ms. Wong, thank you. Does any other reason include DMC? Our position is that DMC is a private contract. The applicant has to ensure that the operation of BHUs is in compliance with the DMC. That is the responsibility of the owner. And as for any other reason to be considered, it depends on the circumstances of the case. For instance, if there are complaints from neighbors, will that be taken into account? That depends on the facts of the case. Sometimes there's no need for any complaint. If the neighbor is a junk flat, for instance, that is already a major issue. So that will be taken into account in our overall consideration of the application. Mr. Andrew Lam, so you will consider a number of factors, including the any violation of the DMC. Whether the OC gives consent and whether the DMC allows the operation of BHU is a very specific question. Please, if you are able to give me an answer right now, do so. If not, you can think about it and give me a reply later, because there are wide, far-reaching implications. Our position is very clear. It is for the applicant to confirm that the operation is in compliance with the DMC. Even if recognition is granted, if the OC or the DMC doesn't allow the operation of BHUs, then the owner will have to address the issue with the OC and with regard to the DMC. Mr. Lam. So I gather from you that even if there is objection from the OC or a breach of DMC, you will still give recognition. And in answering Ms. Wendy Hong's question, you said that so long as there is no order in breach of the provisions here, you will still grant and recognition. So the impression I got from you is that there can be disputes, but the applicant will have to deal with it with the OC in accordance with the DMC, and it's not going to be one of your considerations. I just want to get this right while we are scrutinizing the bill. Let me confirm once again that recognition of BHUs is for the administration to consider relevant factors, that is, factors set out in the bill. That is not to be taken that the operator can be free from any provisions under DMC or his liability with the OC. This is very clear. Mr. Tong Li-Jie, I've already said very clearly that for any other reason, you should better state any other reason that is reasonable for the Secretary to consider. So you should accord a certain degree of flexibility for this clause. This is different from clause 21(3), when we talk about any good reason. It is a judgment for the Secretary, but then you should be more careful with the wording, because that can give rise to controversies. And if after recognition, the buildings department and departments like the fire services department. I'd like to know what it will be the communication between the two. Because circumstances that can invoke Clause 25 for a cancellation of the recognition can happen. Can you tell us how will the two departments communicate? Any other reason, and for good reason? Yes, we noticed that there was such a discussion yesterday, and we will see how this can be clarified. After recognition, what will be our communication with the FSD and the BD? For sure, we must be in very close communication because we have to look at the original building plan in giving recognition and for different statutory orders that will be issued by different departments. We have a regular mechanism for communication. Once the task force for BHU is established, we will set up an even closer communication channel so that when we receive applications for recognition or when we need to cancel a recognition, we'll ensure that we can make a quick decision as soon as possible. Mr. Kenneth Leung. 2C. Under what circumstances the Secretary may refuse and reckon an application? One of the situation is when the officer has been refused to enter an SDU for inspection. Would you allow any discretion? I believe you would not refuse a case once there has been one refusal for entry. Can you give guidelines and a code of practice? For instance, the number of refusal for entry to inspect a flat and whether there will be any warning. Now, this is in relation to Clause 38, entering premises with consent. If we invoke Clause 38, we need the consent of the occupant, and that can be the tenant. If we cannot enter the SDU, that means we cannot gather the relevant information for considering the application. So we may have a few attempts at different times of the days and still we cannot gain access, then we may refuse the application. Thank you. Ms. Sarili. I want to talk about compliance with the DMC. My experience in serving the community is that the public's view is once recognition is granted, they will feel that there is no breach of the DMC. And the Secretary said that the OC might have made a decision in breach of the DMC. I don't believe this is possible because we all have to comply with the DMC. So you have to reconsider the message you are sending out to the community. Because no matter how you explain the provisions, the community will find it hard to understand this logic. Ms. Wong. Granted, we understand that it's important for the public to understand the relationship between BHU recognition and compliance with the DMC. We will issue guidelines for applications. We will remind applicants to ensure that in making an application, they have to comply with all laws related, including compliance with the DMC. Otherwise, they may face liability. if we are expected to consider the DMC in each and every application, we have to bear in mind that the DMC is a private treaty, a private contract, and DMC can come with different terms, and it's quite difficult for us to take care of all types of DMC. Thank you. Ms. Doreen Kong. I just like to say a few more words about the issue of DMC. Is the status of DMC really that low? The government may think that the DMC is a separate issue. Of course, an owner has its liability in a private contract like the DMC, but let's take a look at the case of an elderly care home. Can an elderly care home be operated in a building? Very often, the obstacle is the DMC, is not the government's approval. If the DMC doesn't allow it, there is no way they can operate in the building. And some commercial buildings can be converted to student dormitory unless the conversion is en bloc. Otherwise, it's very difficult for a dormitory to exist in a private building. You may call DMC a private contract, but in many circumstances, the DMC is the major obstacle, because if there is no unanimous consent of all owners of the buildings, you cannot convert or alter the DMC. Now, you should take a look at the case of an elderly care home. The case shows the significance of DMC. And to echo Mr. Andrew Lam's question, if one of the terms in the DMC is that the owner cannot cause any annoyance or disturbance to other occupants of the building, let's say the flat is operating as a BHU and it may cause water seepage to the flats below it, for sure this is a kind of disturbance or nuisance of annoyance. Now, if the OC is aware that there is an application for recognition and the OC writes to the Housing Bureau asking you not to grant recognition. So I'd like to know whether that will be one of the reasons for refusing an application under 18(2)(c). Thank you. If indeed the operation of BHU in a flat has caused water seepage to the unit below that floor, causing nuisance, will we take that into account? For sure we will do so, because the BHU flat has to comply or to meet our basic minimum requirements, and we have to look at the condition of the building as well as the flat. So in the case quoted by Ms. Doreen Kong, for sure we will take that into account. Thank you. Any other questions? If not, we move on to Clause 19. Thank you, Chairman. Clause 19 and Clause 20 on application approved and application refused. To put it simply, the purpose of the two clauses is no matter whether the Secretary approves or refuses an application, notice in writing must be given to the applicant. And if the application is refused, reasons must be given. All right, let's discuss clauses 19 and 20 together. Mr. Tony Zhang.
Well, Chairman, I'd like to know about the date of recognition. How is it going to be decided? Will it be the same as the date of the audit report issued? No, that would not be the same as the date that the audit report is issued. As a matter of fact, if the applicant applies for his own unit as a BHU, as a SDU, he has to submit all sorts of necessary evidence. One of them would be the audit report prepared by the professional. The audit report may be signed by the professional in February, and then in March, the applicant would submit all the necessary evidence. And then after receiving those, we will go vet through all the documents, and then we will issue a recognition notice. And the notice might be issued in May. Then on one of the days in May, that would be the starting or the commencement of the effective date of the recognition. And from that day onward, for 5 years, the recognition will stay valid. Chairman, the audit report will be dated, and there will be a date, and then there would be a difference between the recognition date and the audit report date. So I think you have to inform the applicant that should there be any changes to the audit report, the applicant should inform the administration. Otherwise, intentionally or unintentionally, the applicant may not inform the administration for any changes that occur after the audit report is signed. Ms. Judy Chen, Chairman, I understand that it might be difficult to display the recognition notice at the premises. Would it be possible for the recognition certificate to be provided to the tenants before a tenancy agreement is signed, or would it be put on the web for public checking? Right. If the SDU is recognized, then the information will be set out in a specified website of the buildings of the Housing Bureau. We would specify which compartment of a certain unit is an SDU. So if a tenant wants to rent such unit, it would be easy for him to check the information on the website. Mr. Andrew Lam, well, on the dates of application on approval date and refusal date, you mentioned that there will be about 15 days for checking the documents and then for approval notice to be issued. Do you have any estimate on the days for issuing recognition or refusal notice? I think we have talked about this yesterday. Yes, we hope that we could issue a recognition unit 15 days after all documents are received. We are drawing reference from the practices of other departments to see how much time would be required. Well, of course, we need some time to look at the audit report as well. And there is a validity period for the audit report. We don't want to take it too long to go through the audit report and to issue the recognition order. We will have a service pledge issued later on. In some cases, you might need further communication with the relevant professionals, because in submitting the audit reports, the professionals should have checked all the relevant parts before they sign on the report. Well, for instance, electricity meter. A lot of buildings need to take a lot of time to install an electricity meter. So it's more complex than we imagine. for all these processes to be covered. This is just my view. Yes, please take note of Mr. Lam's view. If members have no further questions, let's move on to Clause 21. Thank you, Chair. Now we are on Division 3, application for renewal of basic housing unit recognition. Clause 21, application for renewal of basic housing unit recognition. Well, basically, this is the same as the first application. For renewal, there is a prescribed fee and also a time. In applying for renewal, it should be made not earlier than 6 months before the end of before the expiry date of the recognition. And the Secretary will consider all information provided, and if everything it's all right, then a renewal order will be issued, and each BHU will be charged $2,400 for renewal. Mr. Andrew Lam? Well, for instance, if a unit is to be subdivided into 3 SDUs, and if there are no changes, then a renewal will be applied. But what about after some time, the owner wants to make alteration to 2 of the 3 SDUs? Does it mean that 2 SDUs have to go through another recognition process? But that's within the same unit, within the same flat. And what about the remaining SDU that is not going to be altered? Should it be renewed, or should new application be made for all 3 units altogether within the same flat? Well, recognition is based on each SDU. The case raised by Mr. Lam, for the one unit that has not been changed, then that unit has to apply for renewal of recognition. For the remaining 2 SDUs, if they are to be modified, then, and if they can meet our minimum requirement, these 2 units have to be applied for recognition again. Well, the processes are more or less the same. For both cases, the owner would need to find a prescribed, recognized professional to look at the units and then to compile an audit report. Next, Mr. Tony Se. Thank you, Chair. We're now talking about renewal for recognition, and there is a time limit, 3 to 6 months before the expiry date. How is it to be decided? Could it be shorter or earlier? Because for subsection 3, it mentions about 3 months before the expiry date. That is, if the renewal application is not made within 3 months before the expiry date, then the Secretary could consider that there is no good reason for it not to apply. Well, the term good reason is quite ambiguous. What does it mean by good reason? Different people may have different views, and the views of the applicant may differ from that of the Secretary. Would it be possible for this time limit, that is 3 months and 6 months, be advanced? I think we should consider more from the perspective of the tenant, because if there is 3 months, the tenant may find it. The tenant may be very, very anxious because it's a short period of time. Yes, Chairman, we have drawn reference from other legislations. For instance, hotels. Hostels, hotel and guest house ordinances. There is a date set down because we have to consider the validity period of the audit report. In considering an application for renewal, If the time is set too early, then we have to consider the validity of the audit report. And after receiving the evidence or documents, we have to spend some time to check them, and then we may have to go do on-site inspection of the units as well. So 3 months should be a reasonable period. As for a good reason, this leaves flexibility for the secretary. If the applicant does not submit application for renewal 3 months before the expiry date, then we leave some flexibility for the secretary to consider special situations. For instance, the applicant might be sick and lives in and has to stay in the hospital during that period. So this might be the reasons that the secretary could consider, and it could be taken as the good reason for which the applicant could not submit application for renewal 3 months before the expiry date. Well, Chairman, I'd like to know if more allowance could be given for application of renewal, because tenants might be the underprivileged group, and no matter what, the time for application of renewal or recognition, if there are changes to the date, then the applicant should inform the administration. Well, my point is that we should let the tenant know as soon as possible about the situation. The tenant should know that, for instance, application for renewal is in process, so that they could rest, they could feel more assured. Yes, when in considering these provisions, we often consider from the viewpoint of the tenants. For instance, in issuing cancellation notice, we mentioned that it has to be issued not less than 30 days before the effective date. If we need more time to consider the documents provided, there will be a kind of transitional arrangement. The unit will not lose its effective recognition if the administration is in the process of considering its application for renewal, and there will always be not less than 30 days for notice to be issued. Ms. Judy Chan, Chairman, I have 2 questions. Will you issue any notice to the landlord to apply for renewal if the owner really misses the expiry date? Would he be held liable, or is there any legal liability for the owner if he does not apply for renewal after the expiry date? Would there be a higher cost for application if it's done after the expiry date? Ms. Wong? Well, it is for the applicant or the owner of the BHU to note the expiry date of the recognition of his unit. We have 110,000 BHUs in the market. If we have to individually inform each owner or operator of the BHU about the soon to expire date of its recognition, then that would be too much workload. We believe that it should be the responsibility of the owner or operator of the BHU to note about the expiry of its recognition. And next question about application after the expiry date. Well, if the owner doesn't submit application 3 months or 6 months before the expiry, unless he has good reason, otherwise we have the right not to accept his application for renewal. That is, the original recognition, after it expires, then it will not be valid anymore. Of course, he could submit a new application for recognition. That is possible. But renewal would be easier and faster, because there will be less procedures. So there is such a difference. Renewal would be simpler, so it would be better for the owner to submit application for renewal rather than wait for it to expire and then submit a new application for recognition again. Well, you mentioned that the administration could refuse to handle or to process his application for renewal. That is may only, right? Well, a new application, that is different from application for renewal of recognition. For instance, if the recognition would expire at the end of February, and if he submit an application for renewal, he could then seamlessly start the operation of his BHU on the 1st of March. But if he doesn't submit application for renewal, then after the expiry on the 28th of February, then he couldn't operate his BHU on the 1st of March because the recognition has expired. Well, for the owner, if he doesn't need to make any alterations to the BHU, he would just need to ask for professionals to do audit and submit the audit report again for new application. Well, of course, if he submit a new application, I can't assure him that he could seamlessly operate the BHU after the expiry of the old recognition. That is, I may not be able to grant a new recognition on the 1st of March. Well, if it is a renewal, then I would assume that he would want to seamlessly operate his BHUs, so the renewal will be valid on the 1st of March. Ms. Doreen Kwong. Chairman. Well, on application for renewal, it has to be submitted within 3 to 6 months. So after it is renewed, well, for instance, you give the renewal 3 months before the expiry date, then he could have a 5-year validity period after that. What about if he received building order after renewal is granted? Just now, Mr. Tony Say asked his question, and then I suddenly thought of whether there should be a responsibility for someone to inform you about any changes. Well, here it mentions that if the unit has any alteration made, the owner has to inform the administration. But if the owner receives a building order after a renewed recognition is granted, then the owner has no responsibility to let you know, to inform you about this building order, right? Yes, thank you, Chair. Ms. Kong has gone into great details about this provision. Well, we have to, the applicant has to ensure that all minimum requirements for BHU has been met, and within the 5-year validity period, if a building orders or a specific notice is issued, then it is for the owner to ensure that the unit is in compliance with the orders. What we will be looking at is whether the BHU has met our minimum requirement within the 5 years of validity period. If there are any changes to these requirements or conditions, the owner has to inform us. But then if the owner has received any other orders, for instance, building orders for the unit, then it is for the owner to ensure that the unit is in compliance with the order. But if it is regarding imminent danger or risk to life or property in the unit, then we have the right to cancel his recognition.
It's only my suggestion. I think you set out to build a very robust regime. But I think there must be a notification mechanism with other departments which issues statutory orders like the FSD. Otherwise, I would feel that I would be safe in the 5-year period once the recognition is granted. Ms. Jovi Chen. Thank you. I would like to follow up on Mr. Tony Jie's question. 21 subsection 3, it says good reason. Now back in clause 18, that's about application, and on renewal, clause 22 subsection 2e. Both these clauses said valid reasons. So why are we using the word good reason here? Because the term sounds quite subjective. It's a subjective judgment whether the reason is good or not. So maybe we should adopt a consistent term like other reasons. I'm just worried that it may give rise to disputes. Thank you, Chairman. We are using different terms. When we said other reasons, that refer to all valid reasons which we consider in granting an approval. But 21.3, we use the term good reason. Here we are dealing with an out-of-time application concerning renewal of application. That is, the landlord has failed to submit a renewal application within the 3 to 6 month period before the expiry date. So that must be a good reason for making that out-of-time application. Any more questions about 21? 22, please. Thank you, Chairman. We are at clause 22, determining application. This clause relates to the considerations to be made by the Secretary on determining an application concerning renewal of BHU. So the factors are basically the same as in clause 18. So that includes any documents or information required from the applicants, the findings of any inspection, and also any code of practice. The Secretary may refuse the BHU renewal application if the application does not comply with the Secretary's requirement of further documents. Denial of an authorized officer's request for entry to an inspection of the principal fact, a liability arising from any statutory order which has not been discharged, or the Secretary is satisfied that any document or information provided is false, the BHU does not meet the minimum standards, there is an imminent danger or risk to life or property in the BHU in the common parts of the building, or any other reasons to cope with any unforeseen circumstances. These are factors to be considered when the Secretary decides to refuse the application. Dr. Starry Lee, 2 questions. Are the opinions given by specified professionals straight, so it's black and white, either it meets the standard or it is not? In my profession, it is not so black and white and binary. If it's so binary, then there may be a lot of challenges in enforcing the law in the future. Now it says the Secretary may refuse the renewal application for certain reasons, but are there also some reasons where the Secretary would accept the application? The BHU regime is for providing adequate housing for people. Now, we are not talking about newly built SDUs. We are talking about converting 110,000 pre-existing SDUs to become lawful and regulated housing units. Ms. Wong. Now, about the professional's report, it's basically a checklist. The professional has to confirm whether all the requirements are met. For example, 8 meters squared in size and all the FS fire services installation are there. So there are objective standards for the specified professionals to decide. Now, concerning other reasons to be considered, concerning the approval of application, our criteria is clear. All the minimum standards must be met, and also there must not be any outstanding statutory orders not having been discharged. Now, we have set the standard on an objective basis. If all the objective standards are met, and if there are no other issues, for example, serious safety issues with the building, then the case would be granted. However, if there are serious safety issues with the building affecting the flags, then we will refuse the application. Now, it says there is no outstanding order concerning the principal flags. Now, what about not having fulfilled the statutory order concerning window and flag inspections, and also building plan and so on? There are also other orders. What if they are not discharged? Ms. Wong, now concerning the building plan, that goes back to the most fundamental question. If the existing layout is different from the building plan kept by the buildings department, then the flag would be considered a SDU. Now, concerning the other factors, that includes the minimum standards of living conditions, and then the flags that the SDU belongs to. For example, flags 18A, it is a 400 square feet flag. Then the flag itself mustn't have any outstanding statutory order. Now, when conducting inspection, we would also consider the overall safety of the building. For instance, if there are building department's order issued against the building stating that it is not suitable for habitation, then we will reject the application. So inspection of flags and window, it may not constitute a refusal factor. So for the building itself, it must not be a dangerous build. It must be a safe building. Ms. Wong? Yes, the building the building's statutory orders may be unknown to the landlord, but the landlord has to make sure that all the orders issued against the flag itself have been discharged with. What about water seepage ratification order issued by the FEHD? Well, that is not included as yet, but we require a waterproofing layer in the toilets. So the professional has to confirm that there is no water seepage. If there are orders issued by the Joint Office for water leakage and seepage against the flags, then the landlord has to notify the professional about that. Clause 23. Clause 23. Application approved. If the secretary approves the BHU renewal application, they must give a written notice to the applicants. No question. 24. Clause 24, application refused. Again, if the Secretary decides to refuse the application for renewal, then the Secretary has to issue a written notice of the rejection or the refusal to the applicant and states the reason why. Now, if a tenancy agreement is still in force, then the Secretary may cancel the tenancy. Now, under the 2+2 tenancy security regime, a BHU cannot be let out if there is no recognition. Now, the notification period would be no less than 30 days so that the affected tenants can move out. The written notice for refusal of renewal would be sent to the applicant and the tenants. The same would also be affixed onto the door of the flat to notify the tenants of the decision. Now, according to Part 7 of this bill, the tenants can file a civil debt compensation claim to the landlord. Mr. Lam Chun Sing. Now, for refusal to renewal, according to the provision, the flats will not lose its recognition at once. The Secretary can appoint a day on which the tenancy ends. So it's less stringent than the other clause. I understand where this is coming from. For example, if some contractors has had their application for license renewal refused because of poor performance, but they will still be allowed to continue with their work for another year until the work is completed. So, similarly, the Secretary for Housing will allow for some time for tenants to be relocated. So my question is whether how long that grace period would be. Will the Secretary appoint a date 1 month in the future for cancellation of tenancy? Ms. Wong? Now, this is an application for renewal we are talking about, so very likely a tenancy agreement is still in force. So normally speaking, the Secretary would give a 30-day grace period for the tenants to make arrangements to move out. So 30 days are the minimum. If the tenant approaches us and asks for more time because of difficulty to find another place to live, we will consider the case. And we will send a team of social workers to offer assistance to the affected tenants. So we will handle the case based on the situation then. Chairman, I understand that 30 days are a minimum. But since you are refusing the application for renewal, there must be some reasons. For example, violating or being in breach of the minimum standards of living conditions set out in Schedule 1 significantly. So the rules have been broken. So we shouldn't allow the SDU to remain in operation for too long. Now, if there is sufficient supply of other alternative housing, like other BHU and light public housing, it shouldn't be a problem for tenants to find another accommodation. I'm worried that the prolonged grace period would lead to risks. I understand. So no less than 30 days is the standard clause. In 22 subsection 2e, it says that if there are imminent danger or risk to life or property in the BHU, then when refusing the application for renewal and deciding the tenancy and ordering the tenancy to be ended, the Secretary can order an immediate cancellation. Let me give you an extreme example. If the building department decides that the building is not safe for habitation, then the notification period would not be 30 days long. Ms. Doreen Kong. Clause 24.2. I thank Mr. Andrew Lam for his inspiration. Subsection 2. Now I approach it from the legal perspective. If the Secretary refuses a renewal application, the Secretary may direct the termination of the tenancy. Now, tenancy agreement is a private contract. For the government to order a tenancy to be terminated, that's huge power. For example, in the UK, a common law jurisdiction, the government has to respect the freedom of contracts. The government can take actions to trigger the termination of the tenancy agreement. But for the government to direct the termination of a contract, that's another thing. So can the Deputy Secretary tell me, in the existing legislation, besides this bill, are there other ordinances where the government can order an agreement to lapse? That's an agreement between two private parties. I think this is a very drastic rule. For example, indecent establishments or vice establishments, there are many old buildings where there are flags being used for vice purposes. Even so, the police can only issue an order to classify that flag as a vice establishment, and then the landlord can terminate the tenancy agreements with the tenants. Even for these extreme cases, the government will not interfere directly. So can the DOJ offer some insights to this Bills Committee? Under what scenarios would the government be so empowered, and is it even constitutional? Ms. Wong? Thank you. Here we empower the Secretary to order determination, to direct determination of the tenancy. The background is under the BHU regulatory or SDU regulatory regime, we offer a 2+2 tenancy protection to the tenants. Now here we are talking about a flat with BHU recognition but was refused upon renewal. So for such a case, the tenant should move out of the flat, because if the SDU is continued to be let out, the landlord would be in breach of the law. So our concern is we can't let the landlord have an excuse. That is the tenancy protection under the SDU regime, that they cannot evict the tenants. Of course, that is a private contract. So the contract is on the premise that the lease is in compliance with the laws in Hong Kong. And in the laws of Hong Kong, there is a BHU regime. If the contract is in breach of the BHU regime, can the contract still be enforced? There is a ground, there is the landlord would be prohibited to lease the BHU out and the contract should lapse.
地俾你買
Well, for the sake of consistency, you may go on. Thank you, Chairman. Under the Landlord and Tenant Consolidation Ordinance, now even if some of the provisions are violated, there is no authority for the government to terminate the tenancy under Cap 7. The parties concerned are only in breach of Cap 7, and it is for both parties to decide whether the tenancy should go on. Now, let's take UBW as an example for a flat that has breached provisions of the Buildings Ordinance. In such an extreme case, there is no authority for the government to terminate the tenancy. Why I'm so anxious about this is, right, you may say that you have all the grounds to do this because the tenant can claim the landlord to cover rent. The right is now granted in this bill. This right is all because of the Secretary's direction to terminate a tenancy, and we must sort out the rights here. Otherwise, I'm a bit worried from the point of jurisdiction, jurisprudence. Thank you. Now we have specified the law. Now, depending on the circumstances, first, we have cancelled the recognition, and therefore the owner has the duty to negotiate with the tenant to move out because he cannot continue to let an illegal BHU. Now, if the two parties fail to reach an agreement, the government need to ensure that the unit will not continue to be let. In Cap 7, we have provided a 2+2 year protection, and therefore we have to strike a balance. We must have an effective enforcement mechanism for BHU, and at the same time we have ensured the 2+2 year tenancy protection. We have the right to remove the letter to ensure that the owner will not use that loophole to continue to let an illegal unit on the ground that there is a 2+2 year tenancy protection. While we have given the Secretary this power, that doesn't mean that for all cancellation cases, the Secretary will issue a notice to an order to terminate the tenancy. Our position is once a BHU is found substandard, there should no longer be anyone living there. Mr. Andrew Lam, in our discussion of the policy aspect, I already said that this is also a legal issue, not just an administrative issue. Now, Clause 31 talks about automatic termination. I find it harder to understand what is meant by automatic termination. Now, if under this piece of legislation, the tenancy is no longer valid, and both parties will have to, or rather, the owner is liable to compensation to the tenant under this bill. If you want to ensure that under this bill there is no excuse for the owner to continue to let the unit to the tenant, let me give you an example. That is also my expectation. As Mr. Ring Kong said, under the Buildings Ordinance, or if I may use another more obvious example, the letting of an industrial flat or unit for habitation. The tenancy should not exist at all because it is in breach of certain provisions. The tenancy has to be terminated in order to ensure the safety of the tenant. Another example is a scene in a movie. A police officer has asked to use a private vehicle. It has to stop in front of the red traffic light, or if it is stopped by a double yellow line, it has to be fined. The issue is how you can rectify the two. You give the secretary the authority to terminate a tenancy. A tenancy can also be automatically terminated. I'm a layman in law, but my query is whether, as a matter of jurisprudence, you have the authority to do this. This is not what I want. I want you to clarify the situation. And what is the basis for the tenant to seek compensation? Is it because of the 2+2 tenancy protection, or is just for the period covered by the existing tenancy? 2+2 is just a tenancy protection. Let's assume that the tenancy agreement covers 1 + 1 year. There is only 6 months left of the first year where the tenancy cannot be terminated. I'd like to know on what basis will the compensation be calculated. Ms. Wong, we worked very closely with the DOJ in drafting the bill. The department has confirmed that the entire bill is in line with our legal principles. And the second question is, once a cancellation order has been issued, the tenants can seek a compensation or equivalent to 3 months' rent or the remaining period of the tenancy agreement. And the parties concerned can also go to court in determining the amount of compensation, and the final amount is entirely the judge's decision. Mr. Rincon, yes, the tenant may recover the compensation as a civil debt, and there can also be an appeal. I'd like to know how the appeal mechanism will work under subclause 6. And I'd like to talk about the difference between common law and continental law. For the former, freedom of contract is very extensive under common law. The right will only be interfered with under very extreme circumstances. This is very different from the situation under continental law. In Hong Kong, we practice common law. And the Secretary commented on this from an administrative perspective. There was no inspiration from the DOJ. If this question cannot be addressed today, I hope we can have a written reply. Deputy Secretary. If the relevant parties appeal against the decision to refuse an application, then what will happen? Now, if a case is under appeal, then there is a suspension in the enforcement of the order. No cancellation order can be issued during the appeal period, and therefore compensation cannot be sought. I thank Ms. Kuhn's question, and then we will give a written reply later. If we have no further questions on Clause 24, let's move on to Clause 25. Thank you. Division 4, cancellation of basic housing unit recognition. Clause 25. Empowers the Secretary to cancel a BHU recognition if the Secretary is satisfied that the unit no longer meets the minimum standards, or refusal for entry to the unit for inspection or rectification period has not been complied with. The recognition or the cancellation will take effect on the date to be specified by the Secretary. In general, the affected tenants will have no less than 30 days to move out. And depending on the circumstances, the Secretary may order that the tenancy be terminated, and then the tenant may seek compensation under Part 7. Just like the case of refusal for renewal, the cancellation order notice will be given in writing, and also it will be posted on the SDU or BHU flat concern, and also the entrance of the building. Mr. Tong Yizhe. Now, for this clause, investigation and some ratification can be carried out for cancellation of recognition. Can you explain further subsection 1A, because the Secretary is given very wide power? Can you further elaborate, apart from paragraph B to E, how the Secretary will exercise its power under A? Thank you. There can be different scenarios. For instance, if we have noticed that orders have been issued by other departments making the BHU no longer being able to meet the minimum standards of living conditions. For instance, first the IFA was 8 square meters, but then on further inspection is smaller than that. That means it no longer meets the minimal standards. And if, according to information, we understand that some minimum standards cannot be met, such as the fire safety requirements, or the corridor narrower than required, there can be different situations. Anyway, we will check against the minimum standards. Information can be based on those from professionals, or information from elsewhere, to show that the standard unit no longer meet this minimum standards. Mr. Zhe, I asked about certification by professionals, and also whether the Secretary accepts the report. There is a time gap between the two, and there may be changes in between, and the applicant has the duty to provide information of such changes to the authority. Now, for situations from B to E, there are cases that can be rectified, and there are things that can't. For instance, in the time gap, departments such as the buildings have issued orders making the unit no longer suitable to operate as a BHU. Very often it's a matter of principle. The Secretary has the authority, but there must be checks and balances to ensure that the exercise of the authority is reasonable. You talked about the Secretary being satisfied with this and that, and there will be inspections as well as information. These are ways to ensure that we feel assured with the Secretary's authority. Yes, if BHU has been certified, and if we notice that there are minimum standards not met, we will usually issue a ratification order. You can rest assured that we will not very likely take the decision to cancel the recognition. Mr. Johnny Ng. Cancellation of recognition is a big matter to both the owner and tenants. So will there be any appeal mechanism? Will there be any independent appeal panel to allow a third party to see whether the situation is valid? Yes, we have an appeal mechanism, and further on, we will have clauses on establishing an appeal panel to be appointed by the chief executive. If any party feels aggrieved by a decision by the Secretary, he can lodge an appeal to the appeal panel. Thank you. Reverend Peter Douglas Goon. Thank you, Chair. I heard that once recognition is cancelled, the tenant has to move out within 30 days. I'd like to know whether that period is long enough. Can there be any discretion? Perhaps 30 days is too short. Well, we just had the view that 30 days is far too long. Ms. Wong. We put in the law that in general there will be no less than 30 days of notice. If in a case a longer period is warranted, we will consider the possibility on the grounds that there will be no delay and a procrastination to the extent that the BHU will not be let out in illegally. Our greatest consideration is whether there is due notice to the tenant concerned. Reverend Kuhn. Well, I am looking from the position of tenants, because most tenants are grassroots. So 30 days is rather a short period. If we are given a very short removal notice, we may have to spend money to address the problem, but if there is no assistance from the government, then it may create difficulty for the tenant concerned. Thank you. We have social work teams to help. In case of a cancellation of recognition, we will have social work teams to help. We can provide temporary accommodation for affected tenants, and as we have more recognized BHUs, perhaps there are units available in the market to resolve the situation. But of course, in reality, we will see whether 30 days is sufficient or not.
Division 5 Supplementary Provisions, Clause 26, Implications of pending applications and appeals on existing BHU recognitions as at expiry of their validity periods. That is, before the expiry of recognition of BHU, a renewal application, if it's still pending, then the recognition would remain in force until the application is settled, or until the appeal board's decision on the appeal takes effect. Any question on clause 26? If not, let's move on to clause 27. Thank you, Chair. Clause 27 is on notification of certain changes. Same as clause 15 about the notification of registration is quite similar. The owner or the operation or the operator, if they have any changes, they have to notify the secretary. And also, if there is a change in the main unit of the flat, then the owner or the operator has to inform the secretary. If either the owner or the operator has informed the secretary, then the provision would be regarded as having been complied. If a person with a reasonable excuse fails to comply with this requirement, then he or she would commit an offense liable on conviction to a fine at level 4. And in case of continuing offense, then a further fine of $700 each day. Legal advisor? Yes, Chairman. This is about changes of the principal flat. I wonder if any code of practice will be issued later, so that the person or the reasonable person would understand what does it mean by a change to the principal flat. Ms. Wong? Yes, in future we will issue further information about what sort of changes we're talking about here. Those are for reference only. For a person in charge of BHU, he would have the duty to ensure that there are no major changes to the unit after a recognition is issued. We will have such guidelines in the future. Any further questions on clause 27? If not, let's move on to clause 28, that is part 5, division 1. Thank you, Chairman. Part 5, there are 2 divisions and 8 clauses. Clause 28 to 35. For division 1, it's about the grace period registration application period, about the pending applications for grace period registration as at expiry of grace period registration application period. Subsection 1. If a grace period application it's pending immediately before the expiry of the grace period application period, and it's regarded as being enforced for the flat from the expiry of the grace period application period until the application is settled. And if the application has been refused, then the grace period is to be regarded as being in force. And if there is a pending of appeal, then the recognition or the grace period registration is to be regarded as in force until the appeal board's decision on the appeal takes effect. All right, any questions on clause 28? No? Clause 29, please. Thank you, Chair. Clause 29, it's similar to clause 28. if immediately before the expiry of the grace period registration application period, a BHU application for a subdivided unit is pending, or no grace period registration is in force for the principal flat, then the recognition is to be regarded as being in force until the application is settled. Or if there is an appeal, then the recognition would be regarded as in force until the appeal decision has been made or takes effect. Any question on clause 29? Let's move on, please. Thank you, Chairman. This is Division 2, countdown period. Clause 30 is on interpretation. Countdown period means the last 6 months of the grace period. Clause 31. Clause 31 sets out that the tenancy of the SDUs, that is about the termination of domestic tenancies for not yet recognized SDUs when countdown period begins. The terms of domestic tenancy begins after the Gazetted date, but before the countdown period begins. And for the purpose of subsection 1, a second-term tenancy of a regulated cycle is an exempted second-term tenancy if the term of the first tenancy begins on or before the Gazetted date. Second situation is that the original tenancy or new tenancy is automatically terminated when the countdown period begins. And also the tenant subsections 3 and 4 do not apply if a BHU application has been refused or there is an appeal lodged. Mr. Andrew Lam. Well, there are tenancy agreements that is terminated under the direction of the secretary, but a different case would be an automatic termination. What's the difference between the two? For automatic termination, who should be responsible to inform the other party about automatic termination of tenancy? For instance, is it the duty of the landlord or to inform the tenant about the automatic termination? Thank you, Chair. About the two different kinds of termination. One, termination directed by the secretary, and second, automatic termination. Well, there are differences. For the first one, for the former, it would happen if, for different reasons, the unit is not suitable, or it has not, or it is not has not met the minimum requirement of a BHU. Then the secretary would direct termination of tenancy, and then the tenants has to move out within 30 days. The administration, of course, would consider various factors before such direction of the secretary is issued. For automatic termination within a grace period, we have 36 months of grace period. For registered SDUs, they could make use of these 36 months to carry out alteration or modification works. But we understand that the owner may procrastinate or perhaps conduct or start the alteration in the last month, and there may not be enough time for the works to be completed. So we need to provide a countdown period in the legislation. That is, it starts from the 1st of September 2029, when the grace period or the countdown period begins. Then the existing tenancy agreement would lapse. We will conduct on-site inspection. If we find an SDU that has been registered, but there is a new tenancy that has begun after the countdown period starts, we would regard this new tenancy as invalid, and the existing tenant has to move out. Of course, the affected tenants would have the right to apply or to go after the owner for compensation. As regard members' question about who should be responsible to inform the affected party about the automatic termination of tenancy. Well, on the 1st of March next year, there will be the start of registration date for the units that are already in existence 3 months before the Gazetted date. They could start registration from the 1st of March next year. And the tenants could check on our specified website to see whether the premises are registered or they have been regarded as or recognized as BHU. Well, after the bill is passed, we will conduct promotion campaigns so that both owners and tenants would know that our countdown period would start on the 1st of September 2029, and there shouldn't be any new tenancy appears after the countdown period commences. I understand that there will be a checklist, a list on your specified website, and then both the owners and the tenants would have the obligation to check the information of their units on that website. So the administration will not inform the owners or the tenants about the situation of the units. Well, if the tenant doesn't know about the situation and enter into a tenancy agreement, then he would also be held responsible. Of course, you mentioned that the administration will look at the actual situations and see which parties should be held liable. But I hope that the administration will make it clearer to all parties concerned. Thank you, Chairman. Yes, we do understand members' concern. The legal obligation would be on the part of the operator. For the tenants, if he entered into a new tenancy agreement, he should be aware that that tenancy might be terminated under certain circumstances, and he has to move out if that is the case. The tenant himself would not be held liable. It's only the operator or the owner that has the legal responsibility. We will explain that in clearer terms in our future promotion efforts. Mr. Tony Se, Chairman, I remember that some colleagues have raised this point. They urge that the government should step up on its promotion effort so that tenants and owners alike would know clearly about the new legislation, and they have to check the situation of the units on the government specified website. So before the lapse of the grace period, if there is a tenancy agreement still in existence, and well, there might be changes to the situation after the grace period. So the tenants have to check the situation closely. Well, as you mentioned that there are legal protection to the tenants, but then the tenants have to take the case to the court, and this might be too complicated for small tenants. They might not have the necessary resources to go to recover their loss as a civil debt compensation. It looks good on paper, but then in reality, I believe that most tenants would not bother to take the case to the court. So I believe that the tenants are the weaker group, so to say. So we should give them more protection, and especially for tenants of SDUs, we should give them proper protection. Ms. Wang, yes, point taken. This is an entirely new regulatory regime. Of course, we will try our best to do as much promotion as possible so that relevant parties would understand the regime in detail. Ms. Dorin Kong, I know that the administration would provide further views to us in written response about the right of the Secretary to direct termination of expiry of tenancy. Regarding termination of domestic tenancies, under the common law, it's different from that under the continental law. It would be either by mutual agreement, or if there are a breach of agreement, then this would trigger a termination of tenancies. However, for automatic termination of tenancies, this is quite serious. So I think in your advice, you should cover the situations. Under what situations would tenancies be automatically terminated? Well, normally a contract would be void or voidable. But then in subsection 3, it says that the tenancy would cease to be enforced for all purposes at all time. I like to hear from the administration or from the DOJ about under what circumstances would original tenancy ceases to be enforced. Well, what about if there are outstanding rentals, or if the tenant has altered the unit? Could you perhaps explain a bit more about this situation? Ms. Wong, regarding the legal questions raised by Ms. Kong, and also the right of the Secretary to direct automatic termination, I will provide response in written form after the meeting. All right, thank you. We have covered this part. And the first item on our agenda for this meeting is covered. So this would be the end of this meeting. Please come back on 10:45. We will have the 6th meeting resumed then, or starts then.